Assalamu alaikum warahmatullahi wabarakatuh. My name is Muhammad Munir.
I'm Muhammad Sharizai Kamal bin Shahidan.
My name is Amir Rafi'i.
And I will be Muhammad Fikri bin Zulkifli.
And my name is Muhammad Firdaus bin Sulaiman.
And today we will be presenting a case review on Tan Wei Hong and Ors versus Malaysia Airlines System Berhad and Ors.
Okay.
This is a civil appeal. Therefore, the parties here referred to are the appellants and the respondent. The appellant is the party who files the appeal, whereas the respondent is the party against whom the appeal is made. In this case, the appellants are the dependents of the deceased who were passengers on the MH370 flight, whereas the respondents are a government agency established under the Ministry of Transport of Malaysia, a public officer who is in control and responsible for the operation of the Royal Malaysian Air Force, and the government of Malaysia. So, the facts of this case is that the deceased were passengers on board the MH370 flight operated by the Malaysian Airlines, which departed from the Kuala Lumpur International Airport on the 8th of March 2014 at approximately 12:40 am. The flight was bound for Beijing in China. However, the MH370 flight never reached its destination and all passengers on board were presumed dead. There was information available on record that showed that MH370 did not leave Malaysian airspace but had in fact made an air turn back towards Penang, a state in Malaysia. So the appellants then filed a lawsuit against the respondents in negligence, and in response the respondents then filed an application pursuant to Order 18 Rule 19 of the Rules of Court 2012 at the High Court of Kuala Lumpur to strike out the claims made by the appellants. The High Court allowed the 3rd, 4th and 5th respondents' application to strike out the appellant's claim against them. In this current case, the appellant is appealing against the decision of the High Court in allowing the 3rd, 4th and 5th respondents' application to strike out the appellant's claim.
The legal issue in this case is whether the High Court correctly exercised its discretion in allowing the 3rd, 4th and 5th respondents' application to strike out the appellant's claim against them.
For the action against the 3rd respondent, the appellant argued that the 3rd respondent owed a statutory duty by virtue of Civil Aviation Act 1969 to track and monitor MH370 while within Malaysian airspace. The second one ensures safe and proper transfer to the next air traffic control tower. This is because MH370 did not leave Malaysian airspace and in fact made a turn back to Penang. The requirement to establish duty of care do not exist. They argue that the damages must be foreseeable, there must be close and direct relationship of proximity between the appellant and the respondent, and it must be fair, just and reasonable to impose a duty of care. Since the requirements are missing, they argued that an action in negligence cannot be maintained. The appellants argued that res ipsa loquitur applies in this case. They argued that the 3rd respondent carried out its duty in tracking and monitoring MH370 while within Malaysian airspace and ensuring safe and proper transfer to the next air traffic control power. The 3rd respondent would not have lost track of the flight. Furthermore, res ipsa loquitur applies since there is absence of explanation for the cause of the incident. The respondent argued that the appellant's reliance on res ipsa loquitur is misunderstood because the appellant must show that the loss of MH370 and the loss of the deceased were under the sole control of the respondents, and this was not the case here. For the action against the 4th respondent, the appellants argued that the 4th respondent owed a duty by virtue of the Chicago Convention Civil Aviation Act 1969 and Malaysian National Defence Policy to investigate and verify any unusual, unidentified, unmarked or unaccounted for aircraft appearing on its radar. Furthermore, they argued that had the fourth respondent monitored the radar in real time and took all the necessary action, the aircraft would not have been lost. Respondent argued that the appellant's claims against the fourth respondent is highly speculative and pure fanciful conjecture. This is also because the appellant were not certain on whether the damage could have been avoided. For the action against the fifth respondent, the appellant argued that the fourth respondent is vicariously liable for the negligence of the third and fourth respondent. This is because fifth respondent is the employer of the third and fourth respondent. Furthermore, the appellant argued that the fifth respondent had a duty to manage this appearance with due care, respect, transparency, and accountability.
Okay, so for the decision, the appellant's appeal in respect of the third and fifth respondent was allowed in the appellant's appeal in respect of fourth respondent was dismissed.
The court allowed the appeal in respect of the third respondent because the third respondent owes a duty of care to the appellant. The third respondent is responsible for tracking and monitoring aircraft, and it was foreseeable that if the third respondent fails to keep track of the MH370, they could lose track of the flight and the loss of the plane, leading to the presumed death of the passenger is not too remote. The court dismissed the appeal in respect of the fourth respondent because the fourth respondent does not owe a duty of care to private citizens. Rather, the duty of the fourth respondent is to guard the safety of Malaysian airspace from external threat. On the top of that, the court found the argument that the aircraft would not have been lost if the fourth respondent monitored the radar and took all the necessary steps as highly speculative. The court allowed the appeal in respect of the fifth respondent because the fifth respondent should remain as a party of the principle of vicarious liability since the High Court has wrongly struck out the claims made against the third respondent.
So, I would like to highlight the application of res ipsa loquitur. The appellants did argue that res ipsa loquitur applies in this case. However, this matter will be decided in trial. It may be difficult to prove negligence by establishing the three elements of duty of care, breach of duty of care, and causation, because in this situation, it is difficult to come up with the details. That is why the appellant wants to apply res ipsa loquitur. For that, three elements must be fulfilled. The first element is that the things that caused the damage must be under the control of the defendants of his servants. In this case, the flight was not under the sole control of the third respondent. Rather, it is under the control of the airplane itself. The third respondent only had a duty to track and monitor the flight. The second element is that the damage is something that will not ordinarily happen without negligence if the defendant takes adequate precaution. So in this situation, an airplane going missing and all passengers are presumed dead. It's not something that happens normally, so therefore this requirement is fulfilled. The third element is that there is absence of explanation as to cause of the accident. In this case, there was no explanation as to how the flight went missing until today. From this, we can see that not all requirements are met, therefore, res ipsa loquitur will not be applicable against the third respondent. However, if the appellant applies res ipsa loquitur against Malaysia Airlines, and not the third respondent, then the course of action may succeed because the flight was under the sole of control of the airplane itself. So on top of that, it is clear that this does not happen normally and there is absence as to how the plane was missing.
Another issue I would like to highlight is the possible defense at the third respondent and Malaysia Airlines may use as a defense. In this situation, the defense of inevitable accident is more suitable. The third respondent and Malaysia Airlines can argue that the flight gone missing is something they could not possibly prevent even if ordinary care, caution and skill is exercised. Another point to add is that when looking at the pilot condition before the flight and weeks before the flight, the pilot seems normal according to news reports, and furthermore, the wife confirmed that there was nothing wrong with her husband before the flight. Therefore, the accident was truly inevitable. However, it depends on the balance of probabilities. If the appellant managed to argue that there was no exercise of ordinary care, caution and skill because the third respondent failed to monitor the flight when it in fact turned back to Penang and was still in Malaysian airspace. Furthermore, by monitoring the flight, the third respondent could have checked with MH370 whether everything is okay and it may prevent the tragedy from occurring. Then the defense may not be able to succeed.
We will have to wait until trial to see what happens next. But what is clear is that the third respondent does have a duty of care towards the appellant. Not only is it foreseeable that if the third respondent fails to keep track of the MH370, they could lose track of the flight, but there was also sufficient proximity between the parties, because if the third respondent could foresee that they could lose track of the flight, then the appellant will suffer. On top of that, it is fair, just and reasonable that a duty of care is imposed toward the third respondent, because the consequences is next time the third respondent will make sure it keeps track of flights within Malaysian airspace. On top of that, if duty of care is not imposed, the repercussion is that the third respondent will continue to fail to monitor and keep track of flights, and more flights can be lost as a result.